All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. We're here for oral argument in case number CACV 21-0130, Lyon v. Helton. These proceedings are being video and audio recorded, so we ask counsel to please identify yourself and your client at the beginning of your argument. As you know, each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired, and counsel for appellee may reserve a portion of the time, or actually no, in this case there is not a cross appeal. So only rebuttal for appellant's counsel if so desired. And also we have read the briefs and we have conferenced in this matter prior to these oral arguments. So at this time, counsel, you may proceed.
Thank you. May it please the court, Bradley Pack appearing on behalf of the appellant, Dr. Michael Lyon. I would like to reserve some time for rebuttal, but I always end up going a little bit longer than I think, so I'll just let you know how much when I get there. The sole issue before the court today is whether the trial court made a mistake of law when it dismissed Dr. Lyon's claims for gross negligence against the defendants, thereby precluding him from having any opportunity to even attempt to prove up his claims in court and to obtain a remedy for the defendant's gross negligence. We submit the trial court did make a mistake in this case when it dismissed those gross negligence claims. As a matter of law, the defendants owed a duty to make the common areas of the Regency House condominium, which were under their exclusive control, reasonably safe for unit owners, residents, and guests alike. Not only did they fail in executing that duty, but their affirmative actions had the effect of turning that garage into a trap that dramatically increased the risk of head-on collisions, thereby increasing the risk of personal injury and property damage.
Counsel, let me ask, we're here and the trial court was asked to consider the adequacy of the pleading, correct?
Correct.
So there's no findings involved, there's no, the question is whether gross negligence was properly pled in your complaint.
That is correct.
Okay, a pretty narrow issue, but an awfully important one, right?
Yes.
And we have a de novo standard to review, is that correct?
Yes.
Okay.
So, Your Honor, let me address then that standard of review. And ordinarily, I wouldn't bother because this court is clearly familiar with the standards governing a motion to dismiss. But I bring it up only because the appellees spent a considerable amount of time in their briefs urging this court to apply the federal court Twombly standard to their motion to dismiss. That is simply not the standard under Arizona law. So under Arizona law, the trial court was obligated to deny the motion to dismiss unless it found that the complaint failed to state a claim under any set of facts that are susceptible to proof, and it's required to accept the facts that we alleged in our complaint as true. Now, the complaint that we filed in this case far surpasses that relatively low threshold to survive a motion to dismiss. Not only did we describe in detail in our factual allegations exactly what imposed the duty on the defendants, how they breached it, what harms were caused to Dr. Lyon, but we also attached an expert report to the complaint that went into even greater detail by reference to specific city codes and county ordinances and safety and design standards for parking garages, exactly how the defendant's conduct made that garage unreasonably safe for anyone who is entering or exiting that garage. Those allegations certainly allege all of the elements of a claim for gross negligence and exceed that threshold for surviving a motion to dismiss. The elements of a claim for gross negligence are a duty, breach, causation, and damages. So I'd like to address each of those elements. First, with respect to duty. What the Martinez decision by the Arizona Supreme Court tells us is that a homeowners association has a duty as a matter of law to make the common areas that are under its control reasonably safe, not just for owners and for residents, but for guests and anyone likely to use those common areas. That duty exists independently of any contract or CC&Rs for the condominium. The complaint alleges that the parking garage that's at issue here was under the exclusive control of the association. That is not disputed. In fact, if anything, the appellees have said we have the unfettered authority to do essentially whatever we want with this parking garage, to reconfigure it in whatever manner we decide is best. The officers of the homeowners association and AAM as its managing agent were the persons responsible for carrying out the association's duty to make the parking garage reasonably safe. So again, that's a duty that exists as a matter of law. Let me move on to, and those allegations necessary to assert that duty were all pled in our complaint. With respect to the breach of that duty, the complaint alleges in considerable detail exactly how the defendants consciously ignored the risk of harm from the unauthorized reconfiguration of the parking garage to cram additional spots into a garage that was already overcrowded. What they did is essentially take a driveway that was a two-lane road with traffic going in both directions like that, and they blocked off one lane of traffic. So now what you have is in that area where they added the 3 parallel parking spots, you have traffic approaching head-on like that. It's even actually worse than that because the location where those 3 parallel parking spots were added is right around the blind corner. So in addition, you have cars coming around the blind corner, very likely, if there's a car traveling in the opposite direction, to have a head-on collision. It actually doesn't take an expert report to understand exactly why that is such a dangerous condition. Nevertheless, again, our complaint did attach an expert report that explained in even greater detail why that is unreasonably dangerous.
Counsel, do you feel like it's needed, the expert report, or are the allegations of the complaint sufficient to overcome the motion to dismiss?
No, we certainly don't feel like we needed to have that expert report, Your Honor. The allegations of the complaint, again, because they have to be taken as true for purposes of ruling on the motion to dismiss, are sufficient. I bring it up to show that we've gone beyond what ordinarily would be done here and supported the allegations of our complaint with even more information that is necessary to survive a motion to dismiss, which is what makes it somewhat baffling as to why the court granted the motion and found that the complaint can't possibly state a claim for relief. In fact, that the court did agree that the complaint was sufficient to state a claim for ordinary negligence because it didn't dismiss those claims. What elevates the defendant's conduct to a claim for gross negligence in this case was a level of absolute disregard for the safety and reasonable expectations of its residents that the defendant showed by their actions here. By making these changes without even obtaining or seeking the consent of the residents of Regency House condominium, they violated their own CC&Rs. They did not consult with a single design professional or person knowledgeable with respect to safety standards for parking areas when they made these changes. They violated city...
Counsel, can you talk to us about what in the allegations as pled supports liability independently or individually on the part of these board members?
Well, Your Honor, the complaint alleges that the board members were officers of the association and it was their responsibility to carry out the duties of the association. Of course, as a corporation, the association can only act through its officers. And by taking on that responsibility, the defendants took on the obligation to carry out the duties of the association with the same level of care that the association itself would be required to exercise.
So acting in their representative capacities.
Well, in their individual capacities as well. Individual officers of a corporation can be held personally liable for a tort if they, and I'm quoting from the court's decision in Bischofson, if they participate or have knowledge amounting to acquiescence or are guilty of negligence in the management or supervision of the corporate affairs causing or contributing to the injury. And what we have alleged is that the defendants did essentially nothing to exercise oversight or care as to how these changes to the parking garage were made. They simply voted.
Let me ask you, your negligence claim was as to the, what I'll call corporate entities only. The
Right.
gross negligence was as to all defendants. I think to follow up on Judge Cruz's question, why or how are the individuals who were, at least in theory, acting on behalf of the corporate entities, how are they individually liable for gross negligence?
Well, Your Honor, because individuals who commit a tort, whether they're acting in their capacity as officers or directors or not, if they participate in the commission of a tort, or if they are negligent in the supervision of corporate affairs or corporate duties, then they may be held individually liable under this court's case law.
Does that maybe stretch that concept a little further than the case law might suggest? And if it doesn't, you didn't name them in the negligence claim.
Well, the reason that we didn't name them in the negligence claims is that the CC&Rs preclude us from doing that. The CC&Rs say that the officers of the association cannot be held liable for their actions except for actions that are committed willfully or with gross negligence. So that's why we didn't plead them as part of our negligence claim. With respect to your question about whether this is stretching that responsibility, or stretching that case law that imposes individual liability on officers and directors, in this case, respectfully, I would assert that it does not. Given the level of...
But we don't, the way you've pled it, we don't have to address that, right? It's only gross negligence, not mere negligence.
That's correct. The claim that is at issue right now is our claim for, it's only our claim for gross negligence against all of the defendants. The court dismissed that on a Rule 54B certification of finality, so the other claims are still proceeding in the Superior Court. Those are the only issues right now. Just to finish that point about the conduct of all of the defendants, the association itself, the officers and directors, and what makes this a claim for gross negligence, again, it's the level of complete disregard for the safety and well-being of residents. It's the failure to do anything to determine whether these changes to the parking garage comply with city or state law. They don't. They violated the law in making these changes. Whether they would be reasonably safe, they're not, and that should be fairly obvious just by looking and thinking about how these changes impact cars that are entering and exiting that garage, and disregarding the serious risk to the safety, well-being, and property of the residents and owners and guests of the Regency House condominium. For all those reasons, we respectfully assert that the Superior Court did make a mistake of law when it dismissed those claims for gross negligence, and we would ask this court to reverse that order dismissing those claims and remand the case back to the Superior Court. Unless the court has any further questions, I'll reserve my remaining time for rebuttal.
No, thank you, counsel.
Thank you.
Good morning, Your Honors. May it please the Court, I am Augustus Shaw with Shaw and Lyons, and I have the pleasure of representing the appellee, Regency House, and subsequent defendants in this matter. I think it's important that this Court concentrate on the pleading requirements in this matter. And I want to highlight a few items in regards to that. First of all, it's clear from the trial court transcript, and I'll quote from that. The trial court stated, from the motion here that is pending, I think based on the allegations in the claim, I don't think the allegations in the complaint state a cause of action for gross negligence. And that's what this is all about, Your Honors. Did the complaint adequately plead a cause of action for gross negligence? And as I represent community associations throughout the great state of Arizona, and when my clients ask me, hey, what are your thoughts on this case? What's the percentage of our chances of victory? I usually tell them, look, I can't predict. But when it comes to gross negligence, I tell them there is a pretty good shot that gross negligence cannot be claimed or cannot be proven, because gross negligence is a very high standard here in Arizona. Gross negligence requires an evil intent, requires an evil mind.
Counselor, what case law says it requires evil intent?
My apologies.
My apologies, Your Honor. In the case Thompson v. Bitter-Built Aluminum Products Company, Site 171, Arizona 550, the plaintiff must show a wrongdoer acted with an evil mind, in addition to outwardly aggravated, outrageous, malicious, or fraudulent conduct. So there must be evidence of an evil mind to harm the plaintiff in particular, and support a finding of gross negligence and punitive damages.
Well, what's the difference, assuming you're correct, what's the difference between that and a conscious disregard for the safety and well-being of residents? Can that be construed as being an evil mind?
Sure. I think what we have to analyze in this matter is we have to analyze the specifics on the ground here and the various different defendants that we're talking about. So let's first talk about the individual officers of the corporation. Under the Arizona Nonprofit Corporations Act, officers, if they rely on the advice of professionals pursuant to the business judgment rule, are pushed into a safe harbor. In this particular situation, the complaint clearly alleges that the officers relied on the work of its management company, AAM, to provide it with drawings and the documents to modify the parking structure.
Counsel, isn't the business judgment rule an affirmative defense that needs to be pled and proved?
It is, Your Honor, but it also goes to the intent of the parties here. And so what I mean by that is, in the complaint, in order to adequately plead gross negligence, you have to adequately plead that the actor acted with intention, or an evil mind.
And help me out, the case that you cited, that standard sounds familiar for punitive damages. What it doesn't sound familiar is for gross negligence. It's not an intentional tort, it's a negligent tort. And what you described would sort of graft onto it the requirement of specific intent.
Sure. The Arizona case law also suggests that gross negligence requires something more than normal negligence.
The mere negligence,
The
absolutely.
mere negligence, yes. And in this case, the pleadings did not plead that something more because of the facts actually either pled or failed to be pled in the complaint. For example, if the complaint would have pled that the individual officers knew that AAM was not qualified to provide them with drawings or help regarding the parking structure, that would be the something more. But there's no pleading there's no allegation in the pleading that AAM did not know what they were doing. There's also no allegation in the pleading that the individual officers knew that AAM was acting improperly. That would be something more. There's also no allegations in the complaint that the officers knew that if they effectuated the plans from AAM, that would cause direct harm to this particular plaintiff, which is the something more needed for gross negligence. That's why the trial court allowed the negligence action to proceed, but stopped the gross negligence, because there has to be something more. In regards to the association, again, if the complaint were to allege that the association knew that its management company was not qualified to provide advice regarding the parking area, that's something more. If there's an allegation in the complaint that the association knew that the plans were inadequate or that the plans could cause harm to the individual appellant here, that would be something more.
Counsel, is the standard actual knowledge, or is it, we're talking about negligence here?
We're talking about gross negligence, Your Honor, which is the difference.
It's the four elements of negligence.
Correct.
Right?
Plus something more.
Plus something more. And does that mean there has to be actual knowledge, or is it still knew or should have known?
Well, even in this case, there's no allegation even if we accept, and I don't mean to interrupt, Your Honor.
Go ahead.
But even if we accept that premise, that it's knew or should have known, there are no allegations in the complaint that allege that. There are no allegations in the complaint that the individual officers should have known that AAM was not qualified. There are no allegations in the complaint that the officers should have known that the plans that would cause harm to the defendant. The allegations...
There is, counsel, an allegation that neither the officers nor AAM consulted with any qualified parking experts prior to implementing the changes, and that they did not ensure that the proposed changes did not constitute a risk to the health and safety and property of the residents.
Yes, Your Honor. But again, that assumes a fact that AAM was not qualified to provide guidance regarding the parking garage without having to consult with a parking expert. So there are no allegations in the complaint that the company AAM does not have parking experts on staff. There are no allegations that AAM was specifically not qualified to provide this information. So although those are allegations that under the standard for a motion to dismiss must be taken as fact, it's not something more. In order to survive a Rule 12b-6 to state a claim for gross negligence, you have to plead this with particularity. You have to specifically plead each allegation of negligence and the something more. And it's important to understand that, as you know, as you all well know, that motions to dismiss are disfavored. So for this trial court to have struggled with this and to have said from the bench, not in a written ruling, but from the bench, that the trial court was not sure, or the trial court did not believe that the gross negligence allegations were pled in a manner to create a claim for gross negligence, I think it's very important here.
But counsel, appellants do plead that AAM breached its duty of care by consciously disregarding its duty to examine its design from a health and safety perspective, by consulting with, I already heard your response to the issue of the parking expert, but aside from the parking expert, just failing to examine the design from a health and safety perspective. If we take that as true, is that not enough?
Well, Your Honor, that's a legal conclusion and not a factual conclusion. That concludes that AAM actually does have a duty to the defendant, which it does not. And there are no allegations, I apologize. It summarizes that there is an actual duty, and there is not an actual duty to the individual plaintiff here. And that's the issue with that allegation. But we have to remember that there are three distinct defendants here. And the gross negligence claim applied to all three defendants. So although the trial court analyzed this as one big allegation, I think it's important that we analyze it as per each defendant. The officers of the corporation, again, there are no direct allegations that they engaged in something more. The only allegation is that the officers of the corporation relied on the opinions of their management company. When it comes to the association, the only allegation is that the association relied on the advice of its management company, and then there are a lot of assumptions. Now, again, those assumptions should be taken as fact, but what should also be taken as fact and what also should be considered is that the association and the individual officers do have the ability to be placed in a safe harbor under the Nonprofit Corporations Act. An affirmative defense, yes, but still should be considered when we consider whether a claim has been properly pled.
At the 12B6 stage, that's your argument?
That's my argument.
What's your
Your Honor.
best case supporting that? I know of none.
I know of none either, Your Honor. But again, we're dealing with gross negligence here.
Understand.
And quite frankly, if this court were to accept the arguments regarding this pleading, it would open the floodgates in regard to volunteer board of directors and homeowners associations. Because the pleading that was pled is so baseline that if this pleading were allowed to be accepted as an adequate pleading for gross negligence, then the standard would be drastically lowered for any other future litigation and would make it extremely difficult to dissuade plaintiffs from filing frivolous or incomplete claims for gross negligence. And that's the important part here, is what the effect of this would be. Again, gross negligence is something that is rare here in Arizona. And there's a reason why it's rare, because it has to be pled very distinctly in order to move forward, because we have negligence. Now, the unique aspect of this case, as pointed out by the appellant, is that the CC&Rs do not allow the officers specifically to be held accountable for garden variety negligence. That's why the appellant has to shoehorn the officers into a gross negligence analysis. And again, allowing that type of shoehorning will have an effect not only in this case, but could have an effect throughout the entire industry. Because it is important, because in most situations there is the ability to seek negligence. Gross negligence has to be reserved as a higher standard. With that, Your Honors, again, the trial court evaluating the transcripts didn't take the gross negligence issue lightly. The trial court struggled with whether there was enough in the complaint to satisfy the pleading standard for gross negligence, and the trial court found that there was not. And that is because of the fact that gross negligence, again, I don't mean to be repetitive, but gross negligence requires something more than garden variety negligence. And to lessen that something more requirement would send shockwaves throughout the nonprofit corporate entity HOA world. Unless there are any other questions, Your Honor, I'll conclude at this time.
No, thank you, counsel.
Thank you.
Just a few points that I'd like to address about counsel's arguments. First, with respect to the standard for gross negligence, one of the benefits of technology is you can do some kind of real-time fact-checking. So I actually looked up that Thompson versus Bitterbilt case that Mr. Shaw cited. It is indeed a punitive damages case, which is not the claim that we're in front of this court on. It is a claim for gross negligence. The standards for gross negligence and punitive damages are not the same. They are different, and we have satisfied all the allegations for gross negligence. The negligence in this case with respect to the officers really comes from the complete failure to supervise the people that they had tasked with carrying out their responsibilities. The District of Arizona Court said in Resolution Trust Court versus Dean, and we cited this in our opening brief, officers cannot close their eyes to what is going on about them in corporate business and must in appropriate circumstances make reasonable inquiry as an ordinarily prudent person under the similar circumstances. So it's not sufficient to just say, well, we told our management company to go out and make these changes to the parking garage, so you can't hold us liable for anything. How could they have just assumed that their management company is in a position to know what the appropriate safety standards are? How can they just say, well, go out and do whatever you want, we'll just assume you're doing everything correctly? That's not the standard that you apply to officers and directors. And as Judge Cruz pointed out, I think we have alleged in fairly sufficient, in considerable detail in our complaint, exactly how the officers and directors in the association really failed to exercise any degree of oversight to ensure that these changes to the parking garage were going to be designed by a company that actually, or a contractor or a professional that actually has the requisite knowledge and experience to make those changes safely.
And counsel, just so that we can leave with fresh in our minds, where is the part where it tips from just being negligent participation on the part of the officers to being gross negligence? Where does that happen?
Well, it's somewhat difficult to define that line and exactly where it lies, but I think you have to look at the totality of all the circumstances in this case. You have to look at the fact that they just blatantly disregarded their own CC&Rs, didn't even bother notifying or getting their residents' consent before they made these changes. You have to look at the fact that they didn't consult a single design professional. And you can't say, well, AAM is our managing agent, so they must be a qualified design professional. They have no idea whether that's the case, and that is contained in our allegations. Not only that, but in reviewing a motion to dismiss, the court doesn't just look at the allegations, but the reasonable inferences to be drawn therefrom. And I think both in the letter and the inferences that you can draw from our allegations, it's that they didn't know whether AAM was a qualified design professional. They didn't do anything to determine.
So you pled that AAM was not a qualified design professional or did not have otherwise on their team an expert?
Well, what we said, and I think you actually quoted our allegations correctly, is that neither the officers nor AAM considered the state zoning requirements or the county or city zoning requirements, that they ignored those, that they consciously disregarded all the health and safety hazards. And I think if it's not explicitly stated, the inference that you can draw from that is that that's exactly the type of thing that a qualified professional would do. AAM did not do that. The officers and directors in the association itself did not consider any of those things. So I think it's fair to draw from that the inference that, look, AAM is not a professional. They are not in the position to be making these types of changes, at least not without hiring a contractor or a subcontractor who does have an appropriate license and knowledge and skill sufficient to carry out these changes that they're making in a reasonably safe manner. Last thing that two things I want to touch on. Mr. Shaw brought up the Nonprofits Corporation Act, which I believe we also cited in our brief, for the proposition that that act has an exclusion for gross negligence. So if anything, that doesn't provide any evidence of a policy in the state of Arizona that if you become a director of a nonprofit corporation, you don't have to worry about how well you perform your duties or whether you perform them safely or what the consequences of your duties are, because you're always going to be excluded from liability under any circumstances. That is not the policy that is embodied in that act, because it does contain an exclusion for gross negligence and for willful misconduct. And lastly, with respect to this concern that we're going to be opening up the floodgates to litigation against homeowners associations and their directors, respectfully, I think, aside from being speculative, that's just simply not true. I can speak from my own experience. I'm the president of my homeowners association. I expect that I am going to be held to a standard of exercising at least a reasonable level of care. And if I do something that is grossly negligent and exposes people to serious risks and injuries, I may be called to account for that. it's not unreasonable to expect that people who serve, even in a volunteer capacity, even without getting paid, even just because they're doing a duty that they think is right and needs to be done, it doesn't mean that they can act without any regard for the consequences of their actions. Your Honors, again, for all the reasons that we've stated, we respectfully assert that the Superior Court made a mistake as a matter of law when it dismissed our gross negligence claims against the defendants and asked this court to reverse.
Thank you, counsel. We thank you both
Thank you.
for your arguments. This matter is now taken under advisement, and we will issue a written decision in due course. We're at recess to set up for the next oral argument.